District of the State of Florida is now in session. The Honorable J.P. Cohen, Judge presiding. All persons having business before this court draw near to the attention and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Eric, where are you sitting now? Where are you sitting? At the circle, Duval County. Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I've been introduced. Let me introduce the other members of the panel. To my right from Orange County, we've got Judge Grosshands. And to my left, we're honored to have an Associate Judge, Eric Roberson, this morning from Duval County, who's going to sit in this morning. We've got 4 cases on the docket. The 4th case is going to require a change in panel, and so I thought that we would go ahead and just take an opportunity after the 3rd case to meet with the lawyers if they would desire for coffee. And at that point, we'll go ahead and change out for a panel for the 4th case. So we've got 4 cases on the docket this morning. Each side will be entitled up to 20 minutes each for their arguments. If the appellant would let me know, I have a default set at 5 minutes for rebuttal, but I'm willing to adjust that in any fashion that you'd like, as little or as much as you would like for your rebuttal arguments. If any of you have any cell phones or any electronic instruments, if you could just make sure that they're on silent so that they don't go off during the course of the arguments and interfere with the flow of the argument. I know that the lawyers in the court would be appreciative of that. So we'll call the cases in the order on which they appear on the docket. We'll begin with the case of POOLE versus State of Florida.
Good morning, judges, counsel. May it please the court, I'm Nancy Ryan representing Ryan POOLE. Mr. POOLE stands before this court convicted of 5 felonies. I've raised half a dozen issues in the briefs. I'd like to begin with the one of those that was preserved for appeal, and that is the issue of whether the state's expert witness, Agent Ramirez, should have been allowed to testify. Since this issue was preserved, I must show that the judge went outside the scope of his discretion in ruling as he did, or else that he abused his discretion. Since the error is preserved, if the court believes that the record does show that a legal error took place, then it is the state's burden to show beyond a reasonable doubt that the verdict was not affected. Agent Ramirez testified that 100% of the time in human trafficking matters, the personal relationship, 100% of the time in prostitution matters, the personal relationship between pimp and prostitute is a toxic one because it is built on exploitation. He further testified that all prostitutes are easy to exploit because of circumstances in their lives that predated their entry into that business. And he further testified that all pimps have the desire and of the ability to manipulate all people around them. This evidence was offered as pure opinion evidence.
All right, let's ask this. What would the standard on appeal be in terms of that decision?
I believe that an error of law has taken place, and that on this very specific area of law, what standard applies to admissibility should result in really de novo review of this sort of sub-issue of what law the judge should have been looking at when he decided whether to admit the testimony. Does that make sense?
Well, it makes sense. I'm not sure that I agree with it, but I understand your argument. But it seems that what you're addressing is an evidentiary issue, though, isn't it? It's the admission of certain evidence in a case.
Yes, Your Honor.
And that seems to me to be an abuse of discretion standard.
Yes, Your Honor, but the discretion of the trial courts, the Supreme Court, the Florida Supreme Court tells us, is bounded by the evidence code and by the relevant case law. And under the evidence code, this evidence should not have come in the evidence was offered as pure opinion testimony admissible pursuant to the Florida Supreme Court's opinion in Marsh v. Value, it was accepted, I think, by Judge Taddy because the federal courts have allowed in testimony of this kind under the Daubert standard. It, of course, became clear 19 days ago that we are now, in fact, a Daubert state.
All right, but at the point in time that this trial occurred, we weren't a Daubert state.
It really wasn't clear. The trial took place in April of 2018. Delisle versus Crane was not decided by the Florida Supreme Court until 6 months after that. It was unclear from 2013 when the legislature amended Section 90.702 very significantly. It was in a sort of limbo, really, as far as the Florida Supreme Court was concerned, whether they were going to accept the amendment.
Yeah, we follow our marching orders from the Supreme Court, who then issued an opinion that said that Daubert was flawed because it involved an access to the courts issue. So that, as this trial court stood at the time of trial, you had an opinion from the Florida Supreme Court that rejected the Daubert standard, which seems to me to leave a Frye standard.
I don't believe this court can apply the Frye standard, though, because the litigants are entitled to the state of the law as it exists on the date, the state of the case law as it exists on the day the opinion is decided, is my understanding, Your Honor.
So at the time of trial, a trial judge has a Frye standard, and then so there's no, let's say hypothetically that the trial judge applied the correct standard, which is a Frye standard, and then the new Supreme Court overturns that and says, no, we're now going to be a Daubert standard as of the time of that opinion. What error are we to correct?
I don't believe that the testimony that was offered was ever admissible on any basis. I believe it was error to admit it at all. It's pure opinion, which at the time might have been admissible, might not. It clearly wasn't admissible under the amended statute because the legislature made it very clear that they were abolishing the Florida Supreme Court's decision in Marsh v. Value, which allowed pure opinion testimony based only on the experience of the officer. This evidence was never relevant. The reliability was never shown because the judge believed that was under the impression that this was pure opinion, exception to Frye, no need for reliability testing.
Why do you think it was not relevant?
It's not relevant under 9401 because it doesn't tend to prove or disprove any fact at issue. There was a case called Flanagan from the Florida Supreme Court, which we've discussed in the briefs. In Flanagan, the Florida Supreme Court held that profiling testimony is not admissible because it doesn't tend to show whether this defendant did what was charged to this victim. This court in Smith, also cited in the briefs, held that the victim's propensity to be victimized is simply not relevant. It doesn't tend to prove any fact at issue. This was a he said, she said case. This was a case where, like in the Williams case that's also cited in the briefs from the second DCA.
It's a little bit more than a he said, she said. I mean, they had cell phone records. They had other, evidence that corroborated, the charges.
I think the emails that the state relies on are inconclusive. The texts are, I would submit that their corroborative value is diminished by the fact that the testimony of both the main witnesses, Mrs. Ennis and appellant, was clearly directed toward explaining how the texts sound like they sound. I would submit
Getting back to Agent Ramirez's testimony, as I understand it, was explaining the grooming and exploitation process that goes on in human trafficking. Is there any argument that's not beyond a common juror's understanding?
Oh, I think that an agent with Agent Ramirez's experience could testify to relevant evidence. I think he's well qualified to explain a rule the jury isn't going to understand. The court probably isn't going to understand either. But there was no fact at issue for it to come in. I would distinguish the U.S. v. Brooks case, which the state relied on here and in the trial court. That's the one from the Federal Ninth Circuit, where the action took place in Phoenix and in San Diego. Mr. Brooks recruited two runaways in Phoenix. Then a prostitute in his organization took the recruits to San Diego, where they would not be able to call on any help, and where she would explain to them what their new lives consisted of and break them into the profession.
Now, Ramirez was qualified as an expert in this case, was he not?
Yes, he was.
And the issue of the propensity of a victim to be victimized, as well as the psychological profile, these are issues that you've raised in your brief. Were those issues made to the trial court? Were those arguments made to the trial court?
I'm sorry, Your Honor, which argument?
We're talking about Ramirez's testimony about the propensity of the victim to be victimized in these cases, and the kind of the psychological profile of victims of these charges. Were those arguments made to the trial court?
I don't remember exactly what defense counsel argued. I do know he relied on the Williams case, where there was an adult victim of an alleged sex battery who testified that she did not consent voluntarily. She acquiesced out of fear of an additional beating. And the state brought in an expert to say, all or most chronic battery victims can't consent voluntarily. The second DCA said that is bolstering of her testimony. It doesn't tend to show guilt of this defendant.
But in this case, what the defense was really arguing was that, correct? That's what they brought up, not the two issues that Judge Cohen just mentioned. But don't you think, in this particular case, this is not what human trafficking looks like to the majority of people. This is not what you see on the news. This is not what the average juror's mind might go to. So why would expert testimony not be beneficial and relevant to describe the way that human trafficking actually looks from the view of the expert?
The charge was that the defendant coerced Mrs. Ennis into prostitution by way of either from providing her with drugs or physical threats. And those are the actions that needed to be proved. The 38-year-old victim was well capable of explaining exactly what happened at every turn. In the federal cases the state has relied on, you have teenagers more or less kidnapped rather than recruited, drugged. They wake up 3 days later in another state. They have no idea what happened in the interim. And in those cases, the federal courts have allowed context to be shown. I submit to you that context is not at issue in this case. She was able to explain exactly what in the state's view underlay each of the 5 charges.
How is it not at issue? Because while the alleged victim got on the stand and testified to that, Mr. Poole got on the stand and denied it in its entirety. So it's something to clarify to the juror what the acts of grooming and exploitation of human trafficking is. That is a disputed issue, it sounds like.
I don't think Mr. Poole was taking issue with the fact that with the human trafficking statute. It was his position from beginning to end that Mrs. Ennis is telling some whoppers and greatly exaggerating what took place and greatly mischaracterizing what took place. That's what was for the jury. The charge and the instructions set out one of the 27 ways to commit this, literally 27 ways to commit this offense. The jury instructions are enough for the jury. They don't need to know how this statute came about, how much human suffering led to it being enacted. They just need to know what was enacted, what was charged, and what was proved about these individuals.
Let's talk a little bit about the fact that apparently the statewide prosecutor might need a lesson in how to read a statute.
Yes, Your Honor. The charge and the jury instruction on count 1 are unclear at best. The state attorney then came in and argued to the jury, don't worry about that language about a venture in the middle of this very difficult to read statute, thereby I think obtaining a verdict by saying, what we really charged, what we meant to charge, and what we're talking about is engaging in human trafficking by way of coercion with an adult.
Now, was that a preserved issue?
It is not, Your Honor. It was not preserved in any way, and so, accordingly, I have argued in the briefs that the assistance of counsel should be deemed inadequate on the face of the record rather than go through a 3850 proceeding.
I know that that's what you've argued, and I'm in working through that argument, the difficulty, it seems to me, is that had it been raised, there would have been the possibility of the state either amending or attempting to amend or attempting to reopen their case.
If it had been raised prior to trial, certainly the state could have fixed the
Or
problem.
even if it had been raised at the time of motion for judgment of acquittal.
Well, we would have vociferously argued against an amendment at that
Well, I
time.
know that, but we don't know what would have happened. That's why I'm struggling with the concept that this is ineffective assistance, on the face of it. We don't know because of the nature of the way that it was charged. Now, whether I understand your argument that the failure to raise that is problematical, but
It's a problematic issue as far as the charging document is concerned. I think it's less problematic as far as the failure to object to all the bolstering and guilt by association evidence that came in through police officers. There can have been no conceivable strategy behind letting the jury hear that, a state attorney believed her in that she passed the case on to the statewide prosecutors. The state believed her because they signed off on the search warrant. None of that was at issue. Who had signed off on what? The defense counsel further let by that the officer himself was asked, "How'd the victim strike you?" And he said, "Straightforward and forthcoming. No objection. No objection to any of this." The guilt by association problem has been expressly addressed in a concurring opinion.
is that the same, straightforward and forthcoming? Is that the same as truthful?
I think to any juror's ears, yes. I think only a lawyer would draw a distinction between a straightforward and truthful. Your Honor.
With the state charging him under the venture section of this statute, are we bound by what the prosecutor said in dismissing it and saying we didn't provide evidence of a venture? Or can we look at the record and look at the evidence to determine whether there was sufficient evidence?
I know, Your Honor, although the state has invited you to do that very thing under the tipsy coachman doctrine. That doctrine applies to trial court rulings, which may have been correct for the wrong reason. That's not the standard we bring to bear when a jury has been led to believe that it is only to look at certain phrases and now wants to rely on the other phrases. I believe that the state is judicially estopped, since I believe that the record can be read to the conclusion that the state obtained its verdict of guilty on count one by way of telling the jury, just look at the beginning and end of the charge, and then having obtained benefit from that, now they want to say, well, the middle of the charge is really where the meat is, and we charged it and we proved it, so it doesn't matter what the jury thought. That's just not the law. We look on any prosecutorial misconduct. We look at whether a rebuke or retraction would have diminished the effect on the jury with evidence. We look at whether the evidence that came on a fundamental error basis, I'm talking about the bolstering and the guilt by association comments by the officers. On those, I must show that the evidence that came in affected the crux of the matter in a way that cast doubt on the outcome. I think we meet those standards, and I don't think that state is entitled to a tipsy coachman type rule. And if I may,
You're into your rebuttal time. That's all I was going to let you know.
I was just going to reserve my time. Thank you, Your Honor.
All right, thank you.
May it please the court, my name is Chris Davenport, and I represent the state of Florida.
Ms. Davenport, aren't the statewide prosecutors supposed to be the more experienced of the prosecutors that we have?
That is the idea of it, yes.
Right. How do you explain, and what do we do with the fact that apparently this statewide prosecutor didn't read didn't read the information or didn't look at the statute?
Well, first of all, this wasn't raised below, so you're looking at, fundamental error or ineffective assistance of counsel on the face of the record, which are both very, very difficult burdens for the defense to meet. I would submit that the information is inartfully drafted. I think they probably tracked the language of the standard jury instruction, which is also a bit inartful. It didn't fail to charge the crime, though, and it charged all of the ways of doing the crime. What is missing from it is the words human trafficking, which was added into our jury instruction, but it's not in the standard jury instruction, which is quoted in our brief. They charged, first of all, they charged the statute. All of these ways of committing the crime are under that same subsection. So the defendant was on notice that we were charging that
I think
subsection.
that they charged a venture?
That they charged venture as part of the charge, yes.
I think
But they
proved-
also,
Do you think they proved venture?
I think they did.
How?
By showing two or more people were involved in this. The way that venture is defined in the statute is pretty broad. It doesn't say willingly involved. It says two or more people involved, and the two of them did a lot of this stuff together.
Well, under that reading of the statute, any prostitute and pimp, for lack of a better word, violate the statute. Is that your interpretation of the statute, then?
No, because there has to be coercion. Some prostitute and pimp relationships, the prostitute is in it willingly. Coercion is a part of human trafficking, which is missing from a regular prostitution relationship.
And who are the two or more people in this scenario?
The defendant and the victim. There was nobody else involved. That's why the prosecutor kind of punted on that.
Is there any law one way or the other that says a victim can or can't be a part of the venture?
There is no law that we could find on that specific issue, so we are left with the plain language of the statute. And under the plain language of the statute, all it takes is two or more people, not two or more willing participants, not two or more people knowingly involved or intending to be involved. I mean, it's defined very broadly.
What other aspect of the statute was proven and given to the jury?
Engaging in human trafficking and attempting to engage because, he was trying to. Just like they charged in the information. Both of those things are mentioned in the information. It says the defendant engaged in or did benefit financially by receiving something of value. And when you see how the standard jury instruction with the brackets so you can see the alternatives, that modifies participation in adventure. So when you're talking about the financial benefit aspect of human trafficking, that's the venture part. And the victim benefited financially too. She was coerced, but she's part of the venture. She had her bills paid. He controlled all the money, but she didn't not benefit financially. So under the plain language of statute, we did prove venture.
How is branding established in this case? He's not there. What evidence was there that he directed that, insisted upon it, or otherwise procured the branding of the victim in this case?
I believe that's exactly what the victim testified. He denied that. He said he was surprised to see it, but I believe the victim specifically testified. She was told it's time to get branded now, and so she did. He was not there, but he directed it. And I would note that this is not raised as an issue on appeal.
Right.
Can
Let's
you-
talk, oh, I'm sorry, go ahead.
Go ahead. Can you talk a little bit about the officer's testimony as far as the credibility issue that they've raised as fundamental error? That he said he found her straightforward and forthcoming.
Well, I will say this. I believe that I'm being straightforward right now. You have no idea if I'm being truthful. I think they
No,
are different things.
We've seen you argue before.
So I hope you find me to be
true.
truthful, but they're two different things. And how the victim reacted to that interview, he didn't just say she was straightforward and truthful. He said other things with that. That she was detached, or I would have to find the specific testimony, but it wasn't just straightforward. And he never said truthful. He wasn't commenting on her credibility. He was commenting on her demeanor when they first interviewed her.
And what was the relevancy of that?
The relevance of that was it ties into the expert testimony describing how human trafficking works and what these victims are like.
I don't understand how the two of those things correlate.
Well, one of the things that the expert talked about was that the victims will deny that anything is going on. They will be reluctant to speak about it because they only speak when they're directed to speak by their pimp. So if the officer had said, this is our first time talking to her, she was bubbly and she insisted that this was abusive and she was, the direct opposite of what the expert had said a victim would be like, I think the defense would use that. They did use that in their closing argument. They talked about, how trafficking works and how this victim didn't meet those criteria. So they did use the expert testimony to the extent that they could.
Well, what do you think about the argument that this should be a Daubert standard?
I think that the objection raised below and the issue on appeal is relevance, not reliability or scientific reliability, so I don't think the court needs to address that here.
Well, but they did make the argument below that, that there was no need for expert testimony, that it didn't assist the jury.
Right, but they didn't talk about the scientific reliability of it, and that's where Fry and Daubert are so different. Is Fry, you only look at the scientific reliability if it's, new or novel scientific evidence, versus Daubert, is a little bit more broad in that area. You always look under Daubert as far as whether the method is reliable. There's no argument below or on appeal that this method is not reliable. The argument was it's irrelevant. It's commenting on the credibility of the witnesses. That's where Williams found the error. That's where Flanagan found the errors, because these guys came in and they did the profiles and they said, and this victim meets it. Well, in Flanagan, they didn't specifically say this victim meets it, although the expert had talked to the victim. They never specifically said that, wasn't specifically tied, so the court found harmless error by admitting this.
What case law do you have that supports the admission, Florida case law, that supports the admission of this testimony in trafficking cases?
All of our case law is from the federal courts because it's specific, because it's so on point factually. Human trafficking has been prosecuted more actively in the federal courts than in the state courts. This is my first trafficking case. I'm surprised by that. I'm surprised we don't see more of it. I'm sure we will because there's such an emphasis on prosecuting that now. But the federal courts have been doing it for a while. And when you look at the cases cited in our brief, they are really, really on point as far as what kind of testimony was allowed in this context. The plain language of the statute guiding expert testimony says, expert testimony is admissible if it will assist the trier of fact in understanding the evidence or determining a fact and issue. You should exclude it if the testimony is within the common knowledge of the jurors. The stuff that this expert testified about, I didn't know, and I've been in criminal law for a long time. It's certainly not within the common knowledge of the jurors. It's not, as Judge Grosshans pointed out, this is not a kind of case you see on the news. You see the kids kidnapped and drugged and things like that. That's how you look at trafficking. This is a grown adult woman who was manipulated by this guy. As defense counsel pointed out repeatedly, this was their defense. She could have left him at any time. She went to New York. She was never held at gunpoint by him. She had the opportunity to quit whenever she wanted to. She wanted to do this. She liked the money. That was their defense. And this expert explained how that all comes together and that it's not how you see it on TV, that it's different, it's more manipulative, it's a little more subtle in some ways than how we would think about trafficking.
Yeah, just the reach of this is of concern to me. That it seems to me that the argument that you're making really could apply to almost every prostitute procurer relationship.
Well, but it's not just prostitution. You have to prove all of those other elements, that they were coerced into doing it. I mean, there's a lot of elements that the state had to meet. It's not a typical, what we think of as a typical voluntary, with my pimp, he protects me, and so I give him my money. And I'm doing this because this is how I'm making a living. There's a coercive aspect to trafficking that is distinguished from regular prostitution. And again, that's one of the things that the expert talked about. He talked about the difference between a normal prostitute and a situation like this, where there's all this coercion and all this control, and it's different from the standard prostitution things that we see. And again, that wasn't raised as an issue on appeal. Going back to the information, perhaps it was inartfully drafted. It certainly charged all the elements. If defense counsel had objected below, we could have fixed it. Even at trial, if they had objected at the JOA, we could have amended the information. We can always do that unless there's prejudice. Considering everybody knew what the charges were and what we were talking about here, they couldn't possibly have demonstrated prejudice.
Well, you say everybody knew. It seems like everybody was under an assumption of which way y'all were charging it, but
right, because
reasonable minds can differ as you read that charging document.
well, again, inartful, should have had the words human trafficking, just like the standard instruction probably should have it in there. But it could have been fixed easily because everybody knew what we were talking about. They cited human trafficking, that's the topic. They didn't cite participating in a venture as the charge itself, and they cited the subsection of the statute that includes all of these different ways of proving it.
So is the state's argument that by citing that subsection of the statute, that puts a defendant on notice of all the ways they could be convicted under that?
That is part of our argument, yes, and I think the case law backs that up. You do look at the statutes that's cited.
Didn't the prosecutor effectively concede that they had not shown a venture?
The prosecutor, during closing argument, said, I'm not even going to get into venture. We don't have that here. That's not evidence.
Well, but why shouldn't you be bound by that?
Because it's just a closing argument. We're not bound by what they argue in closing argument. We're bound by the evidence before the court, and we would submit that the evidence before the court showed a venture, the way the venture is defined under the statute. This was just an argument. The jury wasn't bound by that either. Closing argument isn't the evidence. They need to decide based on the evidence. They were instructed on venture. If everybody was kicking out venture, they shouldn't have been instructed on it. It was a part of the instructions, and when you read how venture is proven, I would submit we did prove that here. Unless the legislature wants to amend the statute to make it more hard so that it doesn't include these victim as part of the venture situations. That would be a legislative decision, not a judicial one.
While we're on closings, can you address their arguments regarding the burden shifting
Sure.
as fundamental error? And they cited two specific examples.
On the burden shifting, let's see.
The text messages where...
Text messages.
They brought up.
And the text messages we would submit was a fair response to their closing. This came up in rebuttal. During the defense closing, they said these text messages, they don't show a full picture of the relationship. They only introduced a snapshot. Just the last month and a half, and this went on for a year. They had full access to the text messages. There was nothing special about them, that we were the only ones who could introduce them. Given that argument, we would submit that it was appropriate for the state to respond to that and say, there's thousands of text messages, we picked the ones.
He didn't deny the rape.
Didn't deny the rape is a little bit of a closer call, to be candid. But I will say that this was in rebuttal. During the defense argument, they said you should believe the defendant's version of the rape story. The defendant testified here, and defense counsel said, her version was pretty different from his, you should believe his. So in that sense, I would submit it is certainly arguable that it was proper for the prosecutor to say, okay, believe his. He never said I didn't rape her, because he did not. He denied a bunch of things, but he never denied that, and he did testify. This is not a situation where he was maintaining his right to silence, and as a witness on the witness stand, we can comment on what he said, especially in light of that rebuttal aspect of that. We would submit it's not proper.
And on cross-examination, let's assume that he doesn't discuss it, and on cross-examination, the state doesn't ask him any questions about it. The state still has the burden of proof.
The state does have the burden of proof, and the prosecutor said that a bunch of times. The prosecutor said it at least 3 times. There's citations in the record. The court instructed the jury repeatedly, this is purely the state's burden. The defendant doesn't have to prove anything.
Or disprove anything.
Pardon me?
Or disprove anything.
Right,
Okay?
exactly.
Well, he didn't deny it. Why isn't that suggesting to a jury that he hasn't disproven it?
Because I think it's a proper rebuttal to them saying, believe his story. And his story didn't deny it.
If we were to find it was an improper burden shifting, what's the consequence?
I would submit it, even if it is improper, given the isolated nature of that and the repeated instructions by the court, no burden of proof on the defense, and the prosecutors repeatedly saying, this is my burden, not theirs. Given all of that, it's not fundamental error. I mean, fundamental error, we could not get this verdict without this isolated comment by the prosecutor. I don't think they've even come close to meeting that standard. It's a difficult standard, as it should be, because if they had objected, the trial court could have fixed it. That's why you require people to object, is because it can be fixed below. They can't stand silent and have an easy burden on appeal. That's not how this works. So we would submit that they did not show that this went to the heart of the case. There's a lot of evidence here. It's not he said, she said. It's she said, and her husband said, and her friend said, and the texts, and the videos, and the ads, and the bruises, and pictures of all the bruising. There's a lot of physical evidence here, as well as several witnesses who talked about the changes in her, as well as the victim who testified extensively. The jury got to see her. The jury found her more credible than the defendant by its verdicts. They believed her. So this is not he said, she said. There's a lot of supporting evidence behind that. So that's another part of the fundamental error analysis. They just have not shown fundamental error. If there are no other questions, we would ask you to affirm. Thank you.
Judges, the appellant has taken the position in the briefs that there is cumulative error shown here. There was a lot of bolstering. There were, the proof, which the state now relies on so strongly, did not preclude the version of events that the defendant gave. He didn't say there wasn't a fight on August 5th. He said things did get violent. He gave a completely different version of the events of August 5th. That's the night when the sex battery is alleged. The fact that she was injured is consistent with both stories. There was a great deal of bolstering. I submit that when you look at the argument that the jury found her truthful, they found her truthful in light of the officer's opinions, in light of the reported prosecutor's opinions, in light of this expert testimony, which was truly irrelevant. It really is a relevance question. There was no independent issue that the actual testimony was relevant to. While some background would have been easier for the state to argue against, what their witness actually came in and testified was that all procurer-prostitute relationships are toxic. They said, well, that's relevant because in the Brooks case we were talking about earlier from the Ninth Circuit, the relationship between the girl, Julia Fontenot, and Mr. Brooks was relevant because it was Julia Fontenot, one of the prostitutes, who took the new recruits to California. The expected defense was, well, Mr. Brooks never left Phoenix. He never left Arizona. How can he be charged with interstate transportation of minors? There was an actual issue out there which the relationship between procurer and prostitute was relevant to. It was relevant for the special agent in that case to come in and say, these are hub and spoke arrangements. Mr. Biggs stays where he is and never leaves the state. So there was relevance there. Here the evidence code does not permit this. Section 9404 and the subsections immediately after it talk about how character evidence can be proved. This court in Smith noted that when the state brought in an expert saying, well, you know, most victims of child sex abuse are from broken homes and suffer repeated abuse, this court said that doesn't come in under the evidence code. It's not relevant. It's not relevant to prove any fact at issue regarding this defendant and this named victim.
If I understood your argument earlier, you said Daubert should apply? If we
Well, I
take up
think
that
the amended 90.702 applies. It was in place at the time of the trial. This isn't in the briefs, but several DCAs had already held that it appears that Marsh versus Value is gone. It's not so much a Daubert-Frye situation, since there was no reliability testing done in the trial court, because the state proceeded under the theory that this is pure opinion testimony based on pure experience of the officer, and it comes in under Marsh v. Value, which the legislature had completely undercut back in 2013. It was not clear yet whether that was going to be the law of Florida under the Florida Supreme Court. The state was on notice that it needed to hedge its bets and show, both under the amended statute and under previous case law, that this testimony is reliable and should come in. But it just, I maintain my position that it just wasn't relevant, and it just wasn't ever shown to be reliable. And Marsh versus Value, I think, is clearly gone, which validates this court's decision in Marsh v. Value back in the 90s.
Great, thank you.
I ask the court to reverse on all counts.
Thank you both.